Common question we get: how do we fund trusts? Do I have to move everything into it now? Can I do everything at death? What does that need to look like? The right answer is there's no right answer, right? It's honestly, we prefer a fund at death strategy. So, naming beneficiary designations with the trust's name, having the will, pour over will, basically naming a trust as its remainder beneficiary after both spouses are gone. But the way that we utilize trusts are usually in an asset protection strategy. So it's usually for immature or young minor beneficiaries. So we essentially expect or hope that the parents will actually live long enough that the trust will no longer be needed. So it's easier for us and for the parents to beneficiary designate that type of a trust on their 401k, on their life insurance as a secondary beneficiary. Because the hope is that we at some point cross some sort of age-based threshold. Maybe that's 30, 25, 26, something like that, where the trust will no longer be needed. So if that comes to fruition, if that's the case, it's easier to then tweak back the beneficiary designations to name the kids outright than it is to move an account back out of a trust, right? So when you move a brokerage account or a deposit account into a trust, you have to actually retitle, actually set up new accounts for the trust. So that's quite an endeavor to begin with. You have to actually, set up new accounts. All of your, direct deposits or bill pays, that kind of stuff, automatic transfers, things that are automatically triggered within your account, have to be set up again because you're going to have new account numbers. Then, should everything happen the way that it's supposed to, and you're still alive when your kids hit age 30 or 35 or whenever you wish for them to receive assets outright, you have to then take it back out, because by that point, if you have a trust that says my kids should get all of my assets at age 35, well, if you're still alive when they hit 35, then the trust is not really doing anything for you, right? So if you passed away when they were 20, it's a different situation, right? Everything going into the trust, being held for their benefit until they're 35. But if you don't pass away prior to them hitting 35, the trust becomes sort of an impediment to a streamlined and straightforward succession strategy. So we don't really need it anymore. We can move the beneficiary designations to just their names individually. So when we talk about funding trusts, we try to, as much as we can, utilize transfer on death designations, beneficiary designations, and those sorts of things, naming them as a secondary after a surviving spouse or as a primary if there's no spouse, right? The reality, though, is there are some assets that have to be put into a trust during your lifetime in order for the benefit of the trust to be realized, and sometimes that's real estate. In that sense, we utilize real estate transfer deeds, like a quitclaim deed, in order to move your interest in real property into the trust. We would do that for an ancillary administration avoidance strategy. There are some brokerage type accounts that are not allowed to be designated to a trust. You can't put them on a TOD or a beneficiary designation because of their bank policies. So in that sense, a good example is Vanguard. Vanguard doesn't allow a brokerage account to be transfer on death designated to a trust. So if we want to really eliminate a risk for probate avoidance or for asset protection, we may have to move that account fully into the trust, retitle it into the name of the trustee of the trust, right? And that's fine. That's sort of the way that it has to be. If at all possible, though, we want to make sure that things, if they have to go to the trust, go at death, when you no longer need them and when things will pay immediately, right? It's sort of a same ends by an easier means type strategy. So if that's possible, that's always preferable.